the appeal stands dismissed. Judgment passed by the learned trial court below is affirmed.
Listing of matter.
My lord, for today itself an eviction matter, my lord. Monday we have been served with a notice to vacate the land, my lord, within a period of 7 days, and next Monday is the last date, my lord. Kindly, my lord, at 2 p.m. or we have already filed, my lord, it is with serial number also.
If you can bring it before the court rises, and take
My
it.
lord, I will try my best, my lord.
But upon service to
Yes, my lord, we have all the service and we have informed them also, my lord, that we are praying, my lord. Obliged, my lord.
Please, Your Lordship, I wish to mention for listing of repetition and contempt petition, my lord, next week, my lord.
next week.
May please, Your Lordship, I beg to mention for listing of a repetition on Thursday, Lord.
What is the subject matter?
Subject matter is eviction from tribal bill, Lordship. The case was at the final disposal phase.
No, Thursday we can't go for a final. Just before holidays may not be. We have it in July
After vacation.
after for final. Let us have it on 23rd of July. 23rd July.
Oh.
Is corrected in the bank.
May I please, Your Lord? Lordship, I beg to mention item number 2. I seek a password for today, my lord.
You wait for your turn.
May I please, Your Lord? I beg to mention item 11 of today's list. The engaged counsel could not be present.
Wait for your turn.
The engaged counsel.
Wait for your turn. Mention when the matter is called up. Yes.
May I please, Your Lordship, I beg to mention for listing of a writ petition, the land dispute matter. We are for the respondent, private respondent. Private respondent number 7 got permission from the Revenue and Disaster Management Department of BTC, my lord, to sell his land. However, my lord,
There is an interim order.
yes, interim order where, my lord, the petitioner contended that the land actually belonged to him, my lord. And accordingly, the sale permission that was obtained by us, that is private respondent number 7, was stayed by. Now we have filed an IA to vacate the stay order.
Right.
On Tuesday, my lord.
Huh?
Tuesday.
When is
Wednesday. Obliged.
Well,
Yes.
well, I beg to mention one writ petition for admission column. Actually, matter is relating to land acquisition, and my building was not initially within the parameter. Therefore, I have filed this writ petition, and according to one order, that has been done. Amount has been also affirmed. On the last occasion, I submitted that copy, and Honorable Court directed the Deputy Commissioner to assert, but till date, nothing is done.
When was the last order?
My lord, in the month of April, due to this, already crack is happening, my lord.
26.
My lord.
Yes.
May I please, Your Lord? I pray for listing 2 matter, one for Udall and one for order.
26.
Declare.
May I please? My lord, my senior counsel leading this case, Mr. R.P. Kakoti sir, he is not my lord, well today, and he is suffering from back pain. my lord.
Lordship,
He asked me to come my lord, accommodation.
Lordship, in this case, they have got the earlier, on occasion, the interim order continued. What happened? They have already submitted appeal before the appellate authority, Lordship, before the arbitrator, challenging their, actually, the TZ award. They're pending before the arbitrator, Lordship.
It will be on Monday. Is it all right? Monday?
This Monday? No, Nikki.
24th?
Yes. 24.
23, 27.
Yes. All
Can
right.
it be on 27th, my lord?
27. All right, 27.
Yes.
27.
Because our construction will stop.
27 June.
Yes.
At the
Interim order.
request of learned counsel for the petitioner at Carrying Count. RP Kakoti is
26.
Interim order.
Interim order will continue the next day.
Obligation.
37 MS R Bora appears for NHITC.
That's it. All right.
May I please, Your Lordship? Lordship, I'd like to mention the password for today, my lord.
We are dismissing your matter.
No, my lord, I'm ready to argue the matter on length, my lord. I have
There's
also
nothing
found.
to argue. There's
No,
the,
my
you are
lord, I
filing
have
a
found
contempt. You are filing a contempt alleging willful disobedience of an order where the writ petition was dismissed.
I'm grateful for what has fallen from my lord. My lord has put a very interesting question to me. I had the opportunity to go and research on this topic. My lord, I found some Supreme Court cases on this matter, directly on this matter, whether a contempt lies against this petition or not, my lord. I'm ready to argue on a short recommendation, my lord.
25th,
Much obliged, your lordship.
the request of Learned Counsel. It's not very late.
Much obliged.
Yes, Mr. Chaudhary, good to have you back.
Um, yes,
Yes.
it is my pleasure, Manu, to have you amongst your lordship.
It is always a pleasure to see you in court. I don't know why you want to go away from the court.
Well, everybody wanted to,
Yes,
Manu, page 13, you can see, Manu.
37,
Page 13, 1-3,
1, 3.
1-3.
Yes.
We are having Pattal and my lord, they wanted to evict it, then we came before the worship. Because in spite of the fact that they are having knowledge that this court's order is there, again, they have started, my lord, and they have enforced some portion of the land. So we have come before lordship. my lord.
No, but it is an interim order.
Yes, but the case is still pending, my lord.
So you file an application before the
We
competent.
filed it. We filed before them also.
No,
That
no,
they-
you file it before the court which has issued this order. That
Mm,
is, in spite of the interim order, it has not.
No, my lord,
order
the
has not
part is, one portion of the my land has been, but they have enforced, my lord. One portion of it.
This is an interim order.
Right, true,
You
my
are
lord.
filing a contempt alleging willful disobedience.
Right.
But this order, supposing whatever order is passed, may get altered as the matter progresses. So perhaps it might be better for you to file the application, seeking appropriate orders from the court, saying that in spite of this order, the
My lord, that
been
order
carried out.
already it is there, my lord, because they have violated it, my lord. You will kindly see order entering my lord, page 14. There is a direct, my lord, there is.
No.
Already there is High Court's order, my lord. So
It's
there
not,
is,
it's not that in an interim order we can't issue notice. But the question is, when is the matter fixed?
the next date is when, date not fixed.
Then
Interim continue till today, my lord. Which matter we inform that, even today they are also threatening to come, my lord.
therefore, in fitness of thing, you should have filed an IA before the competent court saying that in spite of this order, it's not being carried out.
No, carry it out, but it is not, what is the direction of kindness on page 14? Under such circumstances, this court therefore direct the respondent authority, more particularly respondent number 2, 3, not to interfere with and disturb of the position of the petition in respect to the land covered by number so and so, including period patta number so and so. The especially what I might is there.
Yes, then now who is
Now,
violating?
now paragraph 10, you look at this, paragraph 10.
10.
Page 7.
Hmm.
They file affidavit of opposition also, my. They know that this order is there, my. They have not come for modification of this order. My. Paragraph 10, you know.
Yes. Who are the respondents?
Yes, your lordship, and we have
Circle officer.
circle officer. Officer
Uh,
in charge.
Who's for the government? Yes. This is a contempt matter, but we want you to obtain instructions as to why this order at page
13, 14, 12,
page 12 onwards,
page 12 put this.
specific direction at page 14 has not been complied with. This is their allegation.
Yes, sir.
So you can obtain the instructions from the circle office. And let us know if no instructions come, we'll issue notice.
Yes, sir.
First, let us find out.
But let us see what is it, because they are even till today they are in the mood. They
We
came.
can't give you further interim orders.
But
because
I'm not
we
saying,
don't
madam.
need-
It is already there, madam. They have to follow the order of this honorable court.
That's right. So let us find out. If not, we'll issue notice. We'll proceed with the contempt matter.
If they take it seriously, it also it can be.
Can you?
I will give copy to her,
Yes,
madam.
you can serve a copy.
Yes, sir.
And you will keep it on 27th of June. You get the instruction 27 June
Yes,
Next.
sir.
next week,
28 June.
28. All right.
20 the last court.
Yes.
Let it be 27.
27.
I will
you
try.
have,
Raj.
you have to
I'll
find
Just,
out
just
why-
instruction.
why
madam.
Yes, I will
banner
try
6
it.
of the order has not been complied with. That.
Yes.
They filed a contempt.
Yes.
Get the instruction.
Yes, sir.
And accordingly we'll pass order. That will be listed on 27th, enabling the learned government advocate MSS forward to obtain instruction from the respondent as to why the direction contained in the order it is going to pass it up is going to
Isn't
has
violated.
not been complied with as alleged by the respondent. The learned government advocate being present in court is requested by the court to obtain instruction from the respondent. Placed again on 27th.
Obliged.
Oh.
That's okay. Actually,
You must provide a copy.
yes, yes. Just now, within 10 minutes. you will-
Lordship, in this case, if there is direction to file the affidavit, Lordship, affidavit ready, we will file it today or by Monday, Lordship.
Mr. N. Goswami, learned government advocate, submits that the affidavit be filed
2 days, Lordship, by Monday.
within 2 days. By Monday. By Monday,
no.
that is 24th. Mr. S. Ahmed, learned counsel. Please again on 26,
Or 27.
27.
Obliged.
My lord, petitioner is a businessman by profession, who runs a furniture shop, my lord. And he has been, my lord, falsely implicated and was arrested on 29/11/23, my lord, in connection with ACB PS case number 103/23. My lord, under section 7A/12 of Prevention PC Act, my lord.
Yes.
Thereafter, my lord, he was arrested, and after release, my lord, he has filed a complaint, my lord, before respondent authorities number 2 and 3, my lord. My lord, may kindly peruse annexure page 30, my lord. The complaint filed, the entire incident is narrated here, my lord. Complaint filed by the petitioner. Annexure E, page 30, my lord.
Annexure?
E, my lord, page 30, 30.
Yes.
My lord, the petitioner has been falsely implicated, and how he has been falsely implicated, my lord, the entire incident is
You
here.
file complaint before under the criminal procedure. Why are you filing a writ petition? You have ample avenues there. File a quashing petition, whatever you want. What is your prayer in the writ petition?
My lord, my grievance is before the respondent authorities, my lord. I have filed a complaint, and they have recorded my statement and also ensured me that they will take action against me, my lord. But till date, no respondent authorities have not taken any action, my lord. And everything is clearly evident from the CCTV
You
footage,
have not
my
filed
lord.
an FIR.
My lord,
You have not filed an FIR,
we have filed a complaint, my lord.
not an FIR.
No, not FIR, my lord.
Then you should have filed an FIR.
FIR is at, my lord. FIR is at page. Yes, my lord. My lord, kindly see page 14, my lord.
1/4.
Entire FIR is against the OC of Dhola police station, my lord. Ajay Kumar Handy.
Who has filed this FIR?
One Rafiq Ali, my lord.
Right. So
Rafiq Ali.
you have
Sorry, my lord, I didn't get it.
there are certain allegations. You are arrested in connection with this FIR, isn't it?
Yes, my lord.
So your allegation is that you have been wrongly implicated, somebody else is responsible, etc. So you have filed or raised all these complaints before the competent.
Before the respondent authorities, my lord,
ADT.
to an
Now, instead of raising this, you should have filed an FIR before the competent authority. Whatever allegations you have made here. What action will the ADGP take unless you file an FIR? They can only take an action in terms of the procedure laid down in law. To put the criminal investigation into motion, it must be through an FIR or a complaint before the magistrate. Mere direction to dispose of is what? What?
my lord, the complaint petition, my lord.
So, but what would you get out of it? You are making all these, you have made this submission, you have made a scapegoat, etc., etc. That's all. This you take your, there is the investigation is complete, charge sheet is been filed? No,
No, my lord.
not filed. It's under investigation.
Yes, this
So these statements you give it to the investigating officer. But if you want any action on the basis of whatever you have stated in the
complaint.
representation or complaint, ordinarily you should have filed an FIR. To file an FIR. So what orders can the court pass? Effective orders. You think about it. Come back next week.
Okay, my lord.
Please on 28th.
Obligement.
The request of the council.
I am appearing for all respondents.
MS Bora for all.
Please, your lordship. The matter is regarding land compensation, lordship.
For acquisition.
Acquisition land. Without issue notice.
I heard the council for big. It is PR Bonto, President 1, MS Bora, President 3, 4, and MS R Bora for National Highway. Constructed. And S Bora again for Union of India. You can appear for Union?
Yes,
Respondent
lordship.
5?
Yes.
Since the respondents are represented by council. Okay. However, extra copies be furnished within a period of 1 week. Okay. Respondents are at different after the
Lordship, regarding interim lordship,
what interim?
compensation not to release.
Pendency of the writ petition shall not be a bar. Consider the claim of compensation be paid to the writ petition.
That is a lordship, the land acquisition matter. No notice has been issued to me.
Whether it is your land,
Yes. Saxonia land, but
how is Exonia your land?
not not actually my land. Only.
Lordship may go into the annexure 9, page 37.
But you are an occupant.
Yes, okay. Occupying till since 40 years. lordship.
Annexure 9.
9, page 37. So this is the letter which has been addressed by the circle officer to the deputy additional DC. A report have been submitted. So from these report, it is very clear that the disputed land doesn't fall under the land which has been allotted for skill development. If your lordship goes to the third part of that letter, that
There are 3.
yes,
Ah.
the verification of the handover documents issued by this office by so-and-so letter shows the government lands allotted along with the total area of land, that is 250 bighas. However, on field, it was found that as corroborated by district project manager training, Dorong District Skill Development Mission and grievance redressal officer, Assam Skill University project report, few GPS coordinates were taken beyond the allotted land. The land in dispute falls beyond the allotted 250 bighas of land. So this report makes it very clear. This is 2024 report, that is of February.
But your lordship, they are already in the process of constructing a wall over there. I filed two petition representations also, your
Where,
lordship.
where,
Representation.
where, page number?
Mm. Page number 19 and page number 25, your
Page number?
19.
Where, do you have any documents to show that the land is in your possession?
I have given some photographs already there, okay? And
How
two
can I-
cell leads are there in my name.
Huh?
Two cell leads are there in my name.
No, you have some document that
Yes, yes, sir.
page 17.
Yes, yes.
It shows it is a government class land.
Yes. Comment.
Yes.
But I'm cultivating some fruits also there. I'm adding my livelihood from there only. No other source of income, your lordship.
Can't just get on a government land and start cultivating without any permission.
No, this cultivation has been going on since 30 years, your lordship, not now. In fact, the Honorable Deputy Commissioner also visited the site back in 2000.
And then he decided to take over the land
Yes,
after
Can you-
visiting it.
yes. Some media portals also reported all those things.
Where is your representative?
Uh, Page number 19, your lordship.
Yes. Get the instructions from the deputy commissioner.
That's it. If at all I go, this is the date is not mentioned in the representation. If at all my friend can guide
When
on
did you
what
submit
date it
it?
has been filed. This is 2023, I suppose, because some number
No,
has
it's
been
earlier
given.
than that, your lordship. Whatever the client gave us,
In that case, the report is the up-to-date report that has been made from the field
no,
verification and the
regarding
GPS
the report,
coordinate.
I want to say, lordship,
That
the
is
report
his
was
annexure.
given, but still a wall has been being constructed there.
This is
So-
his annexure, so
You
I think
get
of-
you get your instructions.
The-
I think based on this letter, he can at best write to the additional deputy commissioner regarding this letter, annexure 9.
You find out.
Yes.
Kindly, sir, your lordship need to notice, because the matter is defined all the way out there.
Lordship, let me have my instruction then.
That's right. Get your instructions. Tell us how soon can you get it? When can you get it?
Go on. Let it be on the reopening date.
17th July?
Yes.
Calculator, waiting time. Government calculator. And it produces by the by undertaking farming state land. Subsequent land development. Thereby damaging it. There is a report of circle of, is the circle of the report?
Yes.
Page number?
It's 37. 37.
Wherein it stated that the land of the particular is not included in the area handed over identified for the land is falls beyond the allotted 250 acres and skill development. That the council, however, submits that this statement is not correct. And boundary wall is constructed. Portion of the land where petitioner is cultivating. The cultivator has was up and has been cultivating the land past 3 decades. It currently government is instructed. Like and by time it is not able to be practice. That's not the appropriate practice. It's extra public furnished within a period of 1 week. from today. Mr. Burua and P.R. Monroe.
I'm for 2 and 3.
P.R. Monroe appearing for respondent 1 and Mr. Burua for respondent 2. Let the matter be listed on 15. Right.
May I please? Lordship, here petitioner are the parents of the deceased who had died due to hit by unknown vehicle. And thereafter petitioner filed two representation. One is before the respondent number 3 and another one is attached to
You're
the,
claiming compensation.
yes, under Assam Victim Compensation.
Yes, any objection?
Lordship, notice may be issued at this stage. Let me get my instructions because it's a motor accident claim type, this thing. The victim died of a motor accident. So perhaps he may have been granted ex gratia under the revision disaster management notification.
Written up 4 weeks. And Mr. S. Burua for respondent number
1, 3 and 4.
1 and 4.
I'm for two respondents.
Yes, 3 for the- Since the council the faculty not to pay for it, but and to be listed again after the SIR.
Deeply
Obliged.
Please, your lordship. The I has come for
I for what?
lordship. I for restraining the. There are two praise, your lordship. One is to restrain conducting any bulbuli fights within the state of Assam, and further declaration from this honorable court to declare bulbuli fights as unconstitutional and violative of provisions schedules of wildlife protection act, your lordship. Lordship, why I'm saying that?
Yes.
Why I'm saying that, lordship, because as per the wildlife protection act, lordship may take the wildlife protection.
What is this IA for?
Also for restraining any bulbuli fights, your lordship.
So you are supposed to file a response.
My God, we have communicated, but we are yet to.
File your response.
On 16th, we have communicated.
Last order says you can file your response.
Lordship, my only anxiety is that, lordship, on 31, on 1 February, 1st February, 6th February, 4th March, 1st February, 1st April, 9th April, and other subsequent days, lordship has, it has taken time to file response. But till now, no response has been
No, in
filed.
the
your
IA.
lordship. Not in the IA, but on the other petitions also, lordship.
But you're pressing the IA now.
I'm pressing the petitions also, lordship. But IA has come for in the, it is in the, it's leading, that's why I'm saying no.
If you want to press the IA, we hear the IA. If you want to press the writ petition, we
I'll
hear
press
the
the
writ petition.
petition, your lordship. Yeah, press the petition.
All right. Yes.
Petition 466,
Yes. 468.
466. that is regarding to Buffalo fight. We have filed two petitions, Lordship. One is
Yes.
regard to Bulbuli fight, one is regard to Buffalo fight.
Yes.
Lordship, the SOP that we have challenged is in page 42. Your Lordship. It is issued by the Political Aid Department.
Yes.
Lordship, may come to the next page, Lordship, 43. That is the guidelines. Lordship. Regarding Buffalo fight, Lordship, here certain guidelines have been given, Your Lordship. First is, Lordship, that the district administration should ensure that all rules and regulations along with the SOP is strictly followed.
You are challenging this notification.
This SOP, Your Lordship.
Is that okay?
Yeah, because of this SOP, in persons with this SOP, Lordship, Buffalo fights were conducted. But in particularly in the SOP, Lordship, the Buffalo fights were allowed to be conducted during 15th of January to 25th of January, Lordship. But beyond that also, Lordship, Buffalo fights were being conducted.
Hmm.
So it was the responsibility of the state, Your Lordship, for compliance of the strict compliance of the SOP. Not to consider the fact that we have challenged the SOP, Lord.
Why are you challenging the SOP?
Because it is unconstitutional, Lordship, because it is violative of the Wildlife Protection and Prevention of Cruelty to Animals Act, Your Lordship. And moreover, Lordship, those are central acts, Lordship. Without amending the, without introducing any state act, Lordship, they cannot, by the way of an SOP, Lordship, the doctrine of repugnancy will come in, Your Lordship.
Response complete?
No, we have not filed. Lordship, some stricture may go, Your Lordship, because in my knowledge, I brought it in record, Lordship, sir, lots of Buffalo fights were conducted, Lordship, beyond that date also, Lordship. In the
You
additional.
are not
activity.
filing any response.
No, till now we have not. But
Do you
because
want to
Lordship
file or you don't want to file?
my lord,
Are you filing, are you proposing to file any
Lordship,
response?
we have communicated, but we are yet to receive instruction. As a matter of fact, Lordship, we also issued instruction not to hold such events, my lord.
But your
But
notification is already there.
subsequently, there was a writ petition pending here, where this honorable court was trying to come to certain terms. Then we issued this notification for conducting the Buffalo fight for a certain period, not beyond that. So we can please, you know, okay.
Why have you not filed an affidavit here where the
No, no.
notification has been put to challenge? What was the order passed by the High Court on 10/10/2023?
That was only Lordship, it is annexed in the eighth petition, Lordship, 10/10/2023, Lordship is 148. One fifty-three is the paragraph 15.
Paragraph
15.
But there is an order of the court directing the government to do it.
Lordship, that is with regard to Lordship may come to page number 45. That is a WT message which was challenged in this writ petition. Page 45.
Okay.
The dates may not tally, Your Lordship, because in the order it is written as 13/5, 13/1/2015. However, in the WT message it is of 12/1/2015.
Yes.
Whatsoever, Lordship. Lordship, may I read, Lordship, the directions of the Honorable Supreme Court of India as contained in the letter number so and so received from Secretary Animal Welfare Board of India regarding banning of all animal races and fights is reproduced below for favor of information, necessary action and compliance.
No, tell us what is the WT about? Why are you reading the
Lordship,
WT?
Lordship, for banning the all fights, all buffalo
There
fights.
is an order of the court directing
Yes,
the
Lordship.
government to look
Thereafter,
into it.
Lordship, yes, Lordship. Thereafter, Lordship. Initially, we had issued the banning order.
Huh.
We
Yes,
have
that
issued.
is
The
when they
state
came
had-
up before the court.
That was challenged. Then that was challenged before
And
the
then
final.
there are 15 days of direction of the court.
Final order is at page 161, Your Lord.
Yes.
Because Lordship, state has come up with a cabinet which was not placed before this honorable court. On this verbal instruction, Lordship, the honorable court has disposed of the matter, stating that there are 7, Your Lordship, cabinet decision that may be taken shall now prevail over the any other earlier orders as regards not allowing buffalo fights during the Bhogali Bihu Utsav, and petitioner or any other intending organizers may make their application seeking permission, and the authorities shall consider the application as per the cabinet decision that may be taken. Very well, Your Lordship. Thereafter, the SOP has come in. Now, the SOP has said from 15 to 25th, Your Lordship, not beyond that. And the guidelines that has been issued, that all are being violated.
Are you challenging the SOP or
Yes,
you are
Lordship.
saying that the fights are being taken place beyond the period mentioned in the SOP?
Yes, Lordship, because Lordship in the first
Yes, what?
Lordship, in the 1st of February, Lordship, on this honorable court has stated that, Lordship, although we have challenged the SOP, however, court has directed that no buffalo fight should be conducted.
No, but this SOP has come pursuant to orders of this court.
Yes, Lordship.
And the court has said that this will prevail.
Lordship, the court has directed that the second Nagraj judgment shall be complied with.
It was from which paragraph?
No, there is no such right.
Which paragraph?
Chaudhary Lalit Nath. It's a long paragraph, longish paragraph, Your Lordship. It starts from para 3, Your Lordship, and even 4 of page 158. Those judgments were even taken care of, Lord.
No. See the operative part of the judgment. What does it say?
Because, Lordship, they have come with a decision that the cabinet will take care of the issue.
That's right. But
Yes,
there
Lord.
is no finding that no buffalo fights or Pulpuli fights in view of the orders
But the
passed by.
Supreme Court judgment has said that, Lordship, that
Is
cannot
it
be.
your case that this order of the coordinate bench is contra the Supreme Court?
No, Lordship, because
Then-
it has not directly stopped the or allowed the buffalo fight also, Lordship.
Yes, madam, you want to submit? Yes. Tell me. Yes.
Lordship, the orders that we've been referring to from the older orders of this honorable court, there was no strict requirement as to how the amendment has been brought about. We have placed this judgment from May of last
Let
year.
me understand one thing. Are you saying that buffalo fights cannot happen under any circumstance?
Yes, sir.
Now, if that is the case, then how does it matter under what manner the buffalo fights are being permitted to be taken by the state? Because this is essentially what the coordinate bench has held, that in view of a decision taken by the cabinet, that will prevail.
Yes, Your Lordship. The reliance that the state had placed in the earlier proceedings and in the court order also, Your Lordship, that we went through this Animal Welfare Board of India 2, that order, it's based on bullfighting and bull racing events that were permitted in 3 states, Your Lordships, Tamil Nadu, Karnataka, and Maharashtra. And these amendments these were by way of state amendments to the Prevention of Cruelty to Animals Act, because it is a concurrent list subject. Now, how all of these 3 states had brought about this permission was to make state amendments to the act. And the Supreme Court in May of 2023 said that these amendments are valid. And relying on these orders, then a plea was made to legalize buffalo fights and bulbul fights in the state of Assam as well. But here there is no state amendment, Your Lordship, to the Central Prevention of Cruelty to Animals Act. There is simply an SOP, and the judgment of the Supreme Court, which is the Constitution Bench, 5-judge bench judgment, was specifically in the context of there having been a state amendment issued, and the presidential assent was taken to take care of the repugnancy. So the judgment itself acknowledges there's a repugnancy between the central statute and the allowing of these kind of events. And that repugnancy in the case of the state of Assam, Your Lordship, we humbly submit, has not been addressed.
This is in terms of the directions of the court.
Your Lordship,
The court had directed the state to come up with a decision, and they have come up with a decision.
Please, Your Lordship, but the decision and the manner in which the decision has been promulgated are both violative of the central statute.
Therefore, essentially, what you're saying is that the direction, the issue, it is the notification may not have been put to challenge in the earlier judgment.
Please.
But this notification is a fallout of the directions of this court.
Please, your lord.
So therefore, ultimately, there was no finding or uh, uh, even by the coordinate bench that for amendment or otherwise, this is how the notification or a state amendment is called for. The plain and simple thing the state appears to, as as it appears to be, state have understood, is that there is a direction of the court. The court has directed the state to take a decision. They've taken a decision.
Your lord. Yes. Your lordship, couple of submissions in that respect. One that the state has not provided any deliberations, any discussion, that response has not been
We
filed by
don't
the
know. So
state.
therefore, you should first
Yeah.
get this order corrected if you think you are aggrieved by this order.
Your lordship, our understanding of the order and my respectful submission is that in this previous order, this honorable court has simply left it up to the government to formulate the right manner to bring about this change,
That's right.
which has not been done.
That's right.
So that-
What is the point of a court directing the government, leaving it to the government to bring it about? Means it has to be brought about as per provisions of law.
Absolutely, your lordship, and that has not been done.
So if that is not being done, then you should perhaps, I'm nobody to give you a legal advice, but I think this order comes in your way. There is a clear deliberation on what has happened, what has been upheld, what has not been upheld, and there was a direction that we leave it to the government to bring it out. That's it. Now, by way of this writ petition, you are trying to reopen this matter, as it appears.
Respectfully, your lordship, in the previous round of litigation, like my colleague has pointed out, the litigation was in the context of a challenge to an government order banning the activity.
Correct.
There was no representation by animal rights organizations. There's no on merits
Does
discussion.
it require, does it restrict the court from looking into the matter in its entirety to say that yes, this restriction, the stoppage or the restrictions on this food fight has been done in terms of the judgment or the law prevailing
Your
in
lordship,
the Central Act.
yes, your lordship. Your lordship, the
Rather,
order.
the court said we leave it to the state government to take a decision in the matter. So that brought out the notification,
Yes,
which
your
you are
lordship.
challenging now on the ground that is violating of provisions of the land.
Your lordship, our submission is that
It is not your case. There is no objection here that the notification is not on court, not before the court, and the writ petition ought not to have been looked. Let the notification be placed.
Your lordship, that writ petition was in a completely different context, since the subject matter itself was a challenge to a previous order which had been taken away. That writ petition had become infructuous, which is why we have brought this as a separate cause of action before your lordship. Because when the decision of this honorable court had come out, it would still up to, and your lordship will see the decision is premised.
We are trying to understand under what circumstances notification has come out.
Yes,
Notification has come out as a sequel to the deliberations before this court ending in this particular order. You're right that it was challenge was regarding stoppage of the full fight. But then there were deliberations led for a direction of the court that the state government should bring out. The court did not say that under no circumstances cannot bring out a notification.
no, your lordship, that's not our submission as well. We are simply saying that your lordship, your lordship will have page 161, the
If
same
it
order.
is- if that there can be no full fight no matter what. That yes, challenge the notification, whatever ground.
Yes,
If it is your case that yes, there can be a full fight, but the manner in which the notification has been brought out, but that's all. It doesn't require a deliberation of whether fight is permissible or not.
no, your lordship. So if you see the main prayers in our writ petition, we've asked for quashing of the SOP. We've also asked for a
Why?
declaratory relief, saying that these buffalo fights and these bulbul fights are page 38 below,
Our work.
are
We did not know.
unconstitutional and in violation of central
Exactly,
statutes.
that's what we're trying to point out to you. That this is what was deliberated in by the court bench. what has been otherwise the court should have dismissed the writ petition, saying that it is not permissible in terms of the provisions of the law.
Your Lordship, that aspect has not been gone into in that previous judgment.
So what are we supposed to do?
Lordship, this new SOP, our humble submission is that is a fresh cause of action.
No, that is a fresh course of action,
Yes, Your
subject to only the limited parameters that this SOP is not issued in terms of law. But if your basic submission, if your foundation is that this SOP not standing under whatever procedure is contrary to the provisions of the Constitution of the law laid down, then this SOP is equal to the order of the court.
I appreciate Your Lordship. So we will be.
Correct me if I'm wrong.
No, I
This is how
appreciate.
this is how I read this order.
No, I appreciate what
Then-
Your Lordship is saying. Which is why we'll be pressing both reliefs separately, Your Lordship, and which is why we've put it in this manner.
First, you have to
The
deal with this order. You tell us how you want to deal with this.
yes, Your Lordship. But right now, primarily our challenge is to the SOP itself, and
There you go again. Your challenge to the, I'm repeatedly asking you, your challenge to the SOP is the procedure or the basic powers vested with the government.
both
which-
Your Lordship. Both Your Lordship.
If it is both, if it is with regard to the basic powers, then you have to come out of this judgment first. Tell us,
Please, Your Lordship. But the state may at least file a response on the procedure of
you
notification
can't
of
compel the state. If they don't want to file, we'll proceed to the hearing. It's up to the state to decide. If they want. How many opportunities have been granted?
Your Lordship, if there is no reply forthcoming from the state, then that may be recorded, Your Lordship, and
We'll
we are
give them
being.
one final opportunity
My-
if you are interested
my-
in file.
Otherwise, we don't need a affidavit because we are bound by the orders
Don't
of
need
the
an
Supreme Court.
affidavit, we'll fix it for hearing.
Please, Your Lordship.
One
Record
last
it and fix it for
opportunity,
hearing.
one last opportunity. If it comes, my lord, we
Third turn it down. Your name, please.
AKVR.
AKD, turn it down. As well as DK Dad. Very good. DK Dad. That is ordered. And a court has telling notification dated. Is the which notification? Is the
28
notification?
December 20.
Motivation at 27 December
24.
2000, page 42.
Notification dated 27th of December 2023 by the political brigade part of in respect of by laying down the guideline for moving by and three by second state for that. On account of that this is notification not have been done and provisions of the prevention of predating as well as
Wildlife
Wildlife Act,
Wildlife Protection.
Wildlife Protection as well as it out by that it would like to be like and take state with knowledge state having you for moving out as well as restriction laid down under like that that
maybe on 31st, your lordship, it is not informed.
Sorry?
31st of July.
30%. In 466,
The 466. What are same lordship? We have challenged the same SOP.
Lordship, interim orders, maybe.
There is no.
sorry?
Lordship, there is an interim order that has already been. There's no requirement.
Wait, please, Your Lordship. But we have already taken steps.
Hmm?
We have already taken steps in this case.
We have taken steps.
Yes, Your Lordship. Service report may be awaited.
It is submitted by the council to the that it is the respondent pursuant to the order dated 005/2024. Therefore, await service report.
There is an interim order, Your
That
Lordship.
will be listed again on 15th of July. Interim order continue till the next week.
Deeply awaited.
My lord, in this matter, notice has not been issued, but wrongly it has come in the admission column, my lord. Your lordship, asked us to obtain inspection, my lord. My lord, inspection has not been received. So may I pray that, my lord, notice may be issued, my lord, formal notice may be issued.
Heard, Councillor Rohit,
In terms of the earlier order, my lord, we have already served the extra copy, my lord.
Bora is for all respondents.
No, my lord, I appear for the only response number 1 2 6, my lord. 6, 7.
4,
1 2 6 and 7, my lord.
1, 2, 6, and 7. MS Vedas appears for respondent. 4. 4. And Mr. S. Borua for respondent number 2.
5.
25.
Director of Women and Child.
And Mr. B. Boy for respondent number 3. Depth of respondent 89 is registered for daily as well as usual court located of 1 take. Is submitted then extra copy of the served. Further copies if required can serve and have to be listed after the return date. Respondents are required to provide the account in the meantime.
Obliged, my lord.
Please. Well, the first of the instruction to the matter.
Lordship, we have not received instruction here, Lord.
How much time do you require
Okay, Lordship, after vacation, this matter. Lord.
after vacation? 15th of July. The request of the council is reported for the time be granted to obtain by the matter. The Mr. appears for Commissioner MS
M. Deca.
MTECA Standing County PhD. Please 15 interim order to pass continue till 15.
Deeply obliged.
Highly obliged.
Please, your lord. File, lordship.
Some NOC filed
Yes, your lord. Mark is flag C.
by the private respondent.
Yes, your lord. Respondent 5.
Yes. Please for respondent 5.
We have.
Private respondent.
Editing electorate, along with.
Earlier lots were directed to produce them. They were not giving the NOC to the GMC. And even after they have sought, Lordship, now they have filed an affidavit after the court order. Lordship will turn to the page number 62, or
Yes.
page number 62, the NOC.
Yes.
Lordship, এটাকে বলা হয় যে left hand of court number 1 so matter may be
Next week.
After this affidavit, my lord, everything has come clear, my lord.
This is in the name of Babul Chaudhary.
Yes, but this is Babul Chaudhary, that particular, this is a residential. Lordship will in the middle, my lord, for residential,
Residential.
and their business is going on.
Yes, my lord.
Next page is the 168 note, 168 under section GMC Act, my lord, that assessment has been done. And Lordship will at the left hand side, my lord, there is a seal of the GMC. If there is a building is in violation of that will not, the assessment will not make the building regularized for any purpose. If the building is in violation of the act, it will have to be demolished or correction has to be made. That correction they have not made. And Lordship will see in the next page is the that is the rateable, the will come notice of demand, that is annual assess. There they have shown it is a commercial. A residential building is being used as a commercial assess, and only for the revenue reason that is used as a commercial. This building is a residential.
residential building are converted to
Conversion you cannot do. Conversion you have to apply under section 18C of the
so they have
building bylaw.
applied.
And they have to pay penalty. Assessment will not convert the building.
This conversion has already been done in lieu of after the notice has been sent to the this respondent of it.
Very well, we'll take it up next week then.
Okay, Lord.
Next week.
Yes, sir.
Next week.
Revenue.
5. It's not.
Please, Your
Problem. This instruction is awaited lot.
Awaited.
Lot. Already we have communicated lot.
Here, my lord, actually, my lord, last quarter, my lord, your document rejected. The respondent authority, my lord, as to whether the that regulation, my lord, rule 2020, 13, my lord, has been gazette notified or not, my lord. My lord, PCBA may also apply this quarter.
Plus, already we have sent the communication lot. Give me one more time.
Next week, my
No, this is not possible.
You have to just tell us whether it is gazette notified or not.
lord. PCB also can apply.
27.
Right.
Okay. It's not 27. The request of the bank, not the government. That. The time.
Obliged.
Here in this case, my lord, the officer of the GMC without authority of law issued notice. Lord, you can see last order dated 31/5/2024 issued by the Honorable Court, page 3, last paragraph. Instruction is also.
My lord, that impugn order, my lord, at page number 23. We have only asked for the petitioner to furnish the GMC tax receipt, no objection certificate, approved pen, occupancy certificate of the building, because there is a complaint.
Before,
But why?
my lord, there you have to issue a notice under section 337 1 and 2. A complaint has come, my lord. Before issuing a complaint, that process will start. A so-called notice will go from under section 337 1 and 2.
Issue a notice that they
My
will
lord,
produce whatever is there.
it cannot be, my lord.
Why?
Cannot, because while issuing a so-called notice, we have to specifically state what are the violation. What is the violation? Because the building they have approved plan as a violation.
On the basis of where is the complaint?
On the basis of a complaint, my lord, there is a complaint, my lord. That's why we are examining it. Ultimately, what it
No,
I
no,
quite
sir, what I'm saying that there is a complaint, but you don't know where is the violation. Therefore, you are inviting them. Find out if there is a violation.
yes. Well, once a complaint has
As
come,
far as for information is concerned, for the officer, unless there is a violation notice, why issue a notice?
no, we cannot issue a violation notice immediately because this is all because of calculation, my lord. There is a NOC given, there is a approved plan occupancy certificate has to be there.
Therefore, you issue a notice saying that we have received a complaint, this is the violation, kindly come and produce all your documents.
That cannot, my lord, violation we cannot say it immediately, my lord.
Cannot
Let
them the power to be
you
shown, my
show
lord.
us on what provision? On what provision you
My
are
lord, because it next notice is coming under 337 1 and 2, my lord.
this notice under what provision?
Because only we are seeking, my lord, what are the,
Unless there is a procedure prescribed, under what authority you are issuing a
my lord, if they note, procedure prescribed is 337 1 and 2 notice, that cannot be vague, my lord. That had to be a specific one, my lord, with all the violations written in them. At the same time, my lord, in GMC notice has been seeking a document from the GMC. Ultimately, if the building comes out to be a,
affidavit, my lord, that
if the building comes out to be a building permission given by GMDA, we will not act on it, my lord. Because before 2014, there are two agencies are giving notice, NOC. My lord. My lord, this is an exercise before he gets the process starts, my lord. If he says that the building has been given by NOC, GMC will not act, my lord. My lord, if I can hand over, my lord.
Yes.
There is a clear power, my lord. Commissioner is mentioning 337.
337 commissioner, but
My
before
lord, even my lord, lordship 2 points are required consideration. The
no,
person
no, this is the old act, my lord. Still not the same.
page 120. It is the
Open up, please.
Yes.
Page number 129 is the 337
Page number
129, my lord. First, it have to be a notice of show cause under section 337 1 and 2. Before the exercise is undertaken, we want that particular document.
which one? Section
Section 337 1 and 2, my lord. 1. This is the exercise which the commissioner will undertake, my lord. And before that, we want to inspect the documents. If all the documents is okay, there is no requirement of issuing notice. The so-called will not go. That entire complaint will be a false one also. Because before initiating a process, we have to examine all these documents. And if the very first document that the NOC has been given by GMDA, GMC will not even take the exercise.
there is a clear indication, commissioner.
Yes, commissioner will
There is
issue.
a my lord, power which has been accessible assistant town planner. He is even not a town planner, madam.
He is not giving any exercise. He is just taking documents. After that, the GMC commissioner will issue notice.
Now, what authority, my lord? There must be a law, my lord. They cannot act beyond the law, my lord. This practice is going on, my lord. Whenever somebody comes, my lord, a fake complaint, my lord, now they issued such kind of notice and here is the person's.
Why don't he want to show that particular document, my lord? That NOC.
That is not an issue. There must be valid notice. We will respond. Written instruction is not there, my lord. Let him place the written instruction, my lord. The authority says what, man. That is important. My brother has to place the written instruction that on the what provision of law, the power has been exercised. Simple, my lord. And by whom?
See, this 337
Yes.
is to be issued when there is any violation
Yes.
terms of 320. 337 in any building erected, re-erected with contravention of any
Yes.
development scheme under 320.
Before that,
Now, you come to 320. GMC Commissioner, upon information in his possession,
that possession, my lord, that by the document they will hand over. This person will hand over some certain document. This is the NOC, this is the assessment list, and this is the occupancy certificate. Then the process will start. It is before the process being started. Because the document will not be sought by the commissioner, that the officers of the GMC will seek the documents. After examining the documents, commissioner will react. If there is violation, if there is no violation, the commissioner will not act. They will discard that complaint. Even referring to the GMDA, my lord, if there is a
pre-access has to be done, there must be provision of law, my lord. They cannot issue the notice which is not provided by law, my lord, and the person who is not otherwise authorized, my lord.
this is a letter only demanding seeking
Then,
notice.
my lord, anybody can issue notice, my lord, for any purpose, my lord. I don't know for what purpose. Is it for assessment? Is it for violation of building laws, or is it for taxation? Nothing, my lord. My lord, the story is that, my lord, the facts is remains, my lord. One land broker is acting, my lord, behind the scene, my lord, against which we have filed an FIR, my lord.
That's a separate issue, my lord.
And now he's also complaining before ASCB. Everywhere he's running, my lord, to harass us. 80 years old person, my lord. This practice is going on, my lord.
Lordship will recall, my lord.
who are from
Lordship will recall that item number 41. Item number 41, we have given the same notice, but they are not revealing it.
item 41.
Oh, so sorry, item 14, my lord. Same notice. Earlier, my lord, at 14. The same notice was given, they are not revealing it. Then what is the NOC? Lordship given them the order
Given a notice, you show us as to what provision you issued the notice.
because before that 3,000 exercise is undertaken.
Who decides that whether before a notice is to be gone or not? Who has decided that? If you have a set of rules, you follow the
No, there is no act, GMC Act, there is no
If the
provision.
commissioner feels that this meeting is directed, let him issue the notice. He can hear it, hear the parties and pass orders, whatever he feels like.
Well, in the notice itself, we have to give the specific of the violation of the
The power to require removal or alteration.
yes, but that will be given by the GMC commissioner. He has the only power. He cannot delegate. But before the exercise is undertaken, we have to get the documents. Ultimately, this complaint may be false. This may be complaint referred to the GMDA.
If it is false, close it.
No, before that, we run to that documents. Maybe false, my lord. If the they hand over the documents, we'll exercise the whole thing and take the decision, my lord. Commissioner will take a decision under
There must be some provision.
No, there is no provision, my lord.
My lord, 37 is important.
37 is a delegation of power.
My lord, that even it is restricted, that 337 provision cannot be
Yes.
delegated, my lord.
Yes, that's why
Despite of that, my lord, the power has been exercised.
no,
but
no,
kindly see
no,
that
it is
what
not
is
under
directed-
337. 337 only by the commissioner.
37.
Before that exercise is done, my lord, these documents are sought.
There is a specific embargo, my lord.
What embargo?
My lord, 37 says the nature of delegation of
Yes.
power, out of which 337 has been prohibited, my lord.
Yes, that I
Despite
agree.
of the power has been, my lord, exercised. Kindly see there, my lord, courage and my lord, careless
That is
attitude.
for 337 by the commissioner. If there is a violation, that notice will come. So called notice and other things.
It would
That
have
will be
been, my
proceeded.
lord. Why this person is jumping into the scene, my lord? Nothing, even, my lord, power conferred on the law.
That is something different, my lord.
Better, my lord, he should justify that this notice has been wrongly issued, my lord. Instead of, my lord, he's defending, my lord, the person who is not otherwise authorized, my lord.
Let him show that NOC. Let him file him before the court. Then we'll.
Why will he file it?
My lord, that's why before the exercise is done, my lord. If a
Who
show,
has from the he raised an issue saying that
No,
there is
there
no
is-
procedure prescribed. There is no authority on an officer subordinate to the commissioner to issue a notice either
No.
prior to or in terms of section 327. You satisfy us that
337
yes,
1 and
it
2
is
notice will be exercised by the.
you show us that this power can be traced to so and so section. We'll accept it.
337 1 and 2 notice will be exercised by the commissioner.
Correct. But
Before-
before that,
Before,
under what?
Yes, my lord, that is the issue, my lord.
before that exercise starts, my lord. It's a serious exercise that will start, my lord. Before that, we want the documents.
Everything
Because
is serious, my
if-
lord.
If,
Is it
if-
less
in the,
serious,
in
my
the
lord?
notice, if a 3,000 notice goes, we have to specify the violations.
My lord, there is a heading
They,
below,
they,
my lord, there
they,
is a
they,
clear
they
cut
don't
clause.
want to diverse how the building has come to that particular place. Simple thing is
When
that
was the building constructed?
they are not disclosing it. They should disclose
My
it.
lord, will respond everything. Let them, my lord, just issue the notice by valid authority of law. My lord, what is the power, my lord? The law.
You come to 379.
Yes. We are not entering by the premises. We just want the document.
This is your provision.
No, no. Yes,
Authorized to, authorized.
and entering manner. This is
Verify, inspect.
verify and inspect, my lord. We cannot make a measurement of the method. Your NOC will have give the all the setback. The moment the setback is diverse, my lord, then the measurement can take place, my lord.
You are collecting taxes, property taxes.
No, that will not show the setbacks, my lord.
It will show you your permission.
No, my lord. That will not because the permission is once it's granted, my lord, it is in the record, but we cannot detect that permission NOC, my
Then
lord.
unless you are able to point out that there is a provision for issuance of a notice.
Because there is a provision is 337 1 and 2. Before that exercise is being undertaken, my lord.
You are harping on the same thing. Before that exercise, some officer of the GMC must be authorized to issue a notice.
No, no, this is just a document, seeking a document.
Whatever it may be, can anybody anywhere ask some documents to be produced?
No, because before the document, we'll have to examine the document, then the
You
exercise.
examine it, tell us under what provision. This is your act.
Look, there
You
is
tell us that under this provision, under this rule, under that notification,
my
you are
lord.
authorized.
When there is also
Execute it.
bylaw.
Lordship will imagine.
You say that no, this provision is
Then, my lord,
reserved for
then my lord, the situation will come, my lord. Lordship will see in the every market, in a shop.
the situation comes, it will come. But we cannot permit you to act anywhere not prescribed under law. You must have an authority prescribed under law. You can't just go into anybody's house and demand any notification or paper. You have to be authorized.
337 1 and 2 notice cannot come at a sense that without giving the specification of the building. That's why the difficulty, my lord.
You make your route. You make your procedure.
My lord, that will another problem will start, my lord. Because lordship will imagine, my lord, that in every shop there is a display of the trade license. Now it will be, my lord, every house they have to display the NOC in the front of the building. That the situation will come.
Please, whatever you have to do, but you are demanding that this authority is competent to issue notice before the notice under the
Yes, because that exercise had to be done without
produce
after
the complaint,
verification.
let us see. You produce the complaint before the court on the basis of which you are raising the notice.
That I'll
Place it before the court. Let us see.
that I can bring it on.
Let us
Lordship.
Better to put them in.
bring it on record.
Lordship.
Mr. S. Chamaria, Mr. S. Bora, Mr. Bora, it is submit that you notice prior the decision being taken by the Commissioner GMC issuance of notice under 337
1 and 2.
1 in GMC Act 97 1. Submit that prior issuance of notice under 337 1 and 2. The preliminary inquiry is required to be made to find out if the complaint received against the property and the person, and whether there is any violation in terms of or in terms of the section provided what you call NOC.
NOC, occupancy certificate,
or
other
related documents.
Other necessary requirements followed by are required to be verified. And if any violations are known, then violation notice may be
1 and 2.
The Bora, however, is not the act. End of the already any officer
Authorized.
authorized any such is looking for the NOC or other relevant documents to be examined and find out whether the violations are there. Or whether construction being fixed was done in violation of the other terms. And if such violations are be then under 7 1 by the summarize empowering business or permit report complaint taken
After vacation, we do.
There's an entry.
Problem.
I am sorry, Miller, earlier because I have taken time to file affidavit, Miller, but I could not file, Miller.
Yes, Mr. Ghosh.
Yes. His dealership agreement was terminated, Miller.
Mr. S. Bodhakur.
Only my lord, my humble submission is
345.
date will be fixed.
Order 3 weeks time file affidavit. PJ Ghosh current counsel. Matter be listed after 3 weeks.
My lord, date kindly be fixed. Otherwise, my lord, I
Not immediately after my vacation, Miller.
On 29th of July.
Yes,
No.
Oblige.
Affidavit has been filed by the state, my lord. The private respondents are yet to file their reply. So by way of the present writ petition, I have challenged the application that I had since filed before the authorities seeking cancellation of the next of kin that was issued in the favor of the private respondents. That application has been kept on hold, my lord. It has been kept in abeyance till the adjudication of a succession case that has been filed by the private respondents. That aspect of the matter I am still challenging. If I may be permitted to highlight the order dated 26/10/22 at page 39. At page 39, yes, that is the first round of litigation. This order will more or less give perspective on the facts for the consideration of my lord. Page 39. It starts at page 40. Heard Mr. S. Chamaria, learned counsel for the petitioner. Also heard so-and-so, learned counsel for the respondents. On the death of his father, my lord, this has to be read as brother of the petitioner, Adilur Rahman. The petitioner was aggrieved that the NOK was obtained by the wife and daughter of the deceased by suppressing the necessary facts that the petitioner is also entitled to the said NOK certificate. Accordingly, the petitioner lodged a complaint before the DC Kamrup on so-and-so, which was registered in so-and-so for cancelling the NOK issued to the wife and daughter of the deceased, Adilur Rahman. This writ petition is instituted on the grievance that although the hearing was conducted by ADC Kamrup, but the so-and-so has not been brought to its logical conclusion and no final order has been passed. Considering the limited grievance raised, we direct the ADC to consider the grievance and issue raised by all the parties in so-and-so and bring the same to its logical end by passing a final order thereon. We clarify that by requiring the ADC to pass a final order, it is not to be construed in any manner whatsoever that this is a direction from the court to pass an order either in favor or against the writ petitioner. The requirement of this order is that the ADC shall pass its own reasoned order. Let the order be passed by ADC as indicated above within a period of 1 month from the receipt of the certified copy of this order, provided that the hearing in the proceeding is already over. In the event ADC requires to give a further hearing to the parties, appropriate order be passed. So this was the order passed by this honorable court,
giving a specified timeline to decide the application. My lord, thereafter, I write to the authority at page 42. This is immediately thereafter, 4th of November 22. So by way of this communication, I beseech the authorities to pass an order. Since there was no compliance, I was since constrained to file a contempt thereafter at page 44, which is forming a part of Annexure 11. Relevant pages at 45. My lord has it. Yes. It says, para number 2, Mr. So-and-so learned counsel appearing on behalf of the respondent 1 and 2 has submitted that the order has been duly complied with. And in that regard, Mr. So-and-so has placed on record a communication dated 3/2/23. So this is where the communication was brought on the record of the court, which is now under challenge. The communication is at page 46. This is what I have now challenged. This is from the office of DC Kamrup. I will read the entire letter. It will give us perspective. So, with reference to the subject cited above, I would like to inform you that an NOK was issued to Afroza Rahman and Azana Rahman, that is, respond number 3 and 4, on so-and-so bearing certificate as the legal heir of Adilur Rahman on the basis of report submitted by Circle Office of Guwahati Revenue Circle. In this regard, a complaint petition was received from you, that is the petitioner, to cancel the NOK certificate issued in the name of Adilur Rahman, and subsequently a hearing process was conducted from the authority to settle the matter as prayed for. In compliance of the order dated 26/10/22 passed in writ petition so-and-so, prior to receipt of the order of this Honorable Court, this office has sought a legal opinion from the government pleader and the Honorable AG Assam, Guwahati High Court, whether NOK certificate issued in favor of Afroza and Adana can be cancelled or not. As per legal opinion received from Assistant Government Pleader, a succession case number so-and-so is pending before the Honorable District Judge, Kamrup Metro in Guwahati. Under the above circumstances, the present petition for cancellation of NOK dated so-and-so is necessary to be kept in abeyance till the decision being given by this Honorable Court. Hence, a concrete decision could not be taken yet. So this is the grievance that I am bringing to.
Under what provision is the NOK?
Under what provision? My lord, that is the state can highlight, because it has been issued by the respondent authorities. So in my case, if something has been issued, it can also be withdrawn. It can also be withdrawn. The fact of the matter is that in the succession case that has been instituted by the private respondent, she has acknowledged me as a legal heir. I will just highlight one page for the consideration of my lord, which is at page number 32. At page 32, this is the cross-examination of Afroza Rahman, Annexure 5. Annexure 5 at page 32. My lord has it. I am Afroza Rahman and I had filed my evidence in affidavit. In my said evidence in affidavit in para 4, the name of the legal heirs is mentioned as Afroza Rahman, Azana Rahman, Rumena Rahman, Dr. Nilufar Rahman, and Atikur Rahman. I am Atikur Rahman. So, in that cross that has been filed by way of evidence, by way of affidavit, I am acknowledged as a legal heir. But this NOK certificate has been obtained behind my back without my knowledge and intention. So, this is what I am aggrieved of, my lord. There was a specific order of this court according a specified timeline to decide. That decision is yet to be passed. In my limited understanding, my lord, if the NOK certificate issued is to be kept in abeyance till the adjudication of the succession, the same should also apply to the private respondents. It cannot operate, in my limited understanding, my lord, I completely bow down, that if something is to be kept in abeyance for me, it has also to be kept in abeyance for the private respondents. Because today, there are tons of
What benefits are being claimed by me?
Yes, precisely. There's a couple of litigation that is since pending in company court, in other particular forums. So by way of this NOK certificate, there is definitely some advantage that is being taken, because, my lord, this NOK certificate was obtained in 2013. I came to know of the same only in 2021, That is when the same was attached in a company petition. In one of the litigation between the parties, it was put in to substantiate and take advantage of certain position. That is that is when I had taken this particular issue before the authorities and sought cancellation of the NOK. Until such time, like from 2013 till 2021, my lord, I had no knowledge.
Lordship, I am appearing.
I'm trying.
Yes.
I'm trying to understand. What benefits are being claimed by the wife and daughter?
Wife and daughter. My lord, to assert their position as the legal heir, since there are a lot of litigations in relation to company assets.
Generally, this is valid for, let us say, pensions or retirement benefits or something like that.
Yes, most definitely.
But it's in the case of property. Merely an certificate, NOK, name there or not there, does it actually result or has the effect of taking away your right?
My lord is absolutely correct. Per se, there might not be. It just because certain positions are being taken to assert themselves as the legal heirs. This is where we are little concerned. The only limited grievance that
You
the
mean to
petition.
say that you are aggrieved by the fact that it may be projected that you are not at all connected to the family.
That is what is happening.
No, totally not, Lordship. I am for the respondent number 3 and 4, Lordship. Here, Lordship may kindly come to the page 6, Lordship, of their petition, Lordship. Paragraph number 2, Lordship. I am reading the first line, Lordship. That the German fact of the instant case is that the father of the petitioner, namely Adilur Rahman, died on 13/11/2012, Lordship. He is totally misleading the petition, Lordship, before this honorable court, Lordship. He is the father of the deceased, Lordship. He is not the son, Lordship, here.
I just
And
clarified that
in-
position at the start
in-
itself. It has to be read as a brother. This was a typographical error. My lord, why will I mislead the court? This is just a type.
And Lordship, in the earlier order also, Lordship, honorable court passed the order, Lordship, which is at page 40, Lordship. Here
Let
also,
us assume he is the father
here.
or he is the son.
Yes, he is not the son or, yes, Lordship.
So,
He is the
is
brother,
the-
Lordship.
Is the brother required
Whether he is the locus to file such a petition,
is the
Lordship.
brother required to be a part of the NOK or not?
Here the NOK issued, Lordship, after date, Lordship, 13/11/2012, Lordship.
Whose
was
names
there.
are there in the NOK?
NOK, Lordship, definitely his wife, Lordship, who is the respondent number 3, Lordship, and the daughter, Lordship.
So no brother, sister, mother, father, nobody name will be there.
Father already died, Lordship.
All right.
Yes.
The given case,
Yes, Lordship.
if he is the
They are
brother,
the near relatives, Lordship.
Then?
They are the near relatives,
so
Lordship.
are you denying the fact that he is the brother?
No, he is not. He is brother, Lordship.
Then his name should or should not be there.
And Lordship, the NOK was issued, Lordship, 26/2013, Lordship. They filed the petition before the respondent number 1, Lordship, on after 8 years,
So
Lordship.
you are representing whom?
I am 3 and 4, Lordship.
3 and 4 means the holders of the NOK.
Yes,
No.
that's right.
Yes, Lordship.
Afroza Rahman and Azana
No,
Rahman.
no, no.
So are you denying that the brother of
He is brother, Lordship.
so if he is the brother, then the correction needs to be done.
His brother, Lordship. And Lordship, in page number 46, there is a letter, Lordship, wherein, Lordship, succession case 136/2013 is pending, Lordship. Today is the date fixed for the judgment, Lordship, in the learned court below, Lordship.
With regard to declaration of a successor certificate, with regard to whatever money.
Yes,
there.
Lordship. Yes, Lordship.
But what has that got to do with the next of kin?
Yes, Lordship. The observation was made, Lordship, after considering the report of the learned leader, Lordship.
Not report, opinion.
Opinion, Lordship.
The rules of the state.
Oh,
What do you say? Sorry?
For the communication of the additional applicability, because of the tendency of the case on this, the
how is it connected?
That part, so far it's been some incertitude. That's
You tell us when you get next week.
Lordship, I will file affidavit, Lordship, so after vacation, maybe
What evidence?
reply, reply. Lord.
Let us have it next week first. We'll give you time to file if required.
Okay. If my lord may have it on Tuesday, Monday, Tuesday, as per the convenience.
matter may come up after that. Stephen is also please.
I'm an outstation counsel taking indulgence. Monday and Tuesday, I'm here, and thereafter it may be taken up post vacation as per the convenience of the court.
Immediately after vacation.
You stay back for 2 more days.
Well, there's some pre-commitment in Delhi. But if my lord is pleased to give a date on Monday, Tuesday, I'll.
All right, let us have it on Tuesday, the 25th. Try to see what it, because it's on a very short point. What has the succession certificate case got to do with the NOK? It is issued by 2 different authorities. The authority, the DC has to verify who are the next of kin of the deceased. That's all. That's all. So see what instructions you can get. You file your affidavit if you want in the meantime. You can
Yes,
file
Lord.
it.
Yes, Lord.
Right. Let the matter be listed again on Tuesday, 25th, enabling the state respondent to complete their instructions and the private respondent may file their affidavit.
My lord, the operation of the NOK may be stayed until then.
Is it stayed?
No, not yet. On the last date, I had pressed only because of the appearance of the private respondent. It was pending.
No, that's what you have to explain.
Yes.
How the NOC is being misused in order to pay for the other way. What
On Tuesday, I will come prepared with it. Obliged.
otherwise it has to carry forward.
Please, I'm sorry. Much obliged.
Mr. Sharma
And that's.
and that appears for statement. Who is A.N. Sharma?
Predecessor count. The earlier count.
Oh, earlier. And,
Air Borrello.
He was from additional AG for the state. Sir,
Air Borrello.